Corrine, the next matter to come before us this morning is State of Ohio versus Frederick West. You have 15 minutes to do with as you wish. The court has read the briefs and we are ready to see when you are.
Thank you, Your Honor. And since unfortunately Mr. Casey has waived, then I don't have to reserve any time for rebuttals. Less confusion. Good morning, and may it please the court. As you know, I'm Jacqueline Corrigan, and I represent the appellant in this matter, Mr. Frederick West. Mr. West is challenging his conviction on 4 grounds, and he's also challenging his sentence. The sentencing error the state has conceded. As far as his convictions are concerned, his first challenge to his conviction is that his rights to a speedy trial under both the Constitution of the United States and the state of Ohio and his statutory speedy trial rights were violated when he was tried over 50 days after the expiration of his speedy trial date. Chiefly, one of the things, well, I should probably explain to the court what had happened in Mr. West's case. His original speedy trial date was calculated as being March 11th, 2014. But of course, there were a couple of continuances. There was one motion filed that I'm aware of, a request for some discovery. Everybody in the case agreed that 35 days were chargeable to Mr. West, and that his speedy trial date was going to be April 15th, 2014. When Mr. West came up for trial on the day before that, on April 14th, 2014, the trial court sua sponte continued the trial until June 9th because there was a murder case that the court was having to deal with at the same time, and there were going to be a couple of other intervening cases that were going to have to be tried that were older than Mr. West's case.
And at that point, did the defense counsel raise the speedy trial issue? Or there was an opportunity because there was a sua sponte order that came out?
Well, Mr. West's counsel had filed a motion that morning prior to that hearing. There was a denial order entered a couple of hours later. The whole issue of speedy trial had come up a few times prior to that. There was a discussion of that in February at a pretrial then. There was an oral motion to dismiss on speedy trial grounds on April 1st. A visiting judge denied the oral motion to dismiss on speedy trial grounds again on April 10th. Again, like I said, about 45 minutes prior to the April 14th trial date, another written speedy trial motion was filed, and again there was an objection prior to the opening of the actual June 9th trial. So it was repeatedly coming up.
And when it repeatedly came up, did it appear that the state was in agreement on what the actual speedy trial date was? Or is this a flexible thing that keeps changing every time it comes up?
Actually, no. From early on, everybody was saying 35 days are chargeable to Mr. West. That means that April 15th is his date. So the court calculated it at 35 days. Mr. West and his counsel calculated it the same way, and so did the state of Ohio. So everybody was in agreement that April 15th was the day. But the problem in this case is that on April 14th, we have a sua sponte continuance. Under State v. Mincy, an Ohio Supreme Court case, and its progeny, unless the court files a journal entry not only explaining the reasons for the sua sponte continuance, but files it prior to the expiration of the speedy trial date. If those two things aren't present, then the continuance is not valid and the speedy trial rights have been violated. Unfortunately, for my client in this case, that journal entry was not entered until 15 days after the April 15th expiration of Mr. West's speedy trial time. Now, the state of Ohio, in its briefing in this appeal, has disputed whether that was violated or not. it actually still was. And I can explain to the court why, if the court would indulge me. The state of Ohio in this appeal has claimed that one of the documents that Mr. West had filed on April 14th tacked and added 7 days onto his speedy trial time. And
that was the notice?
That notice, yes. But that's not a motion that would actually toll speedy trial time. In no way, shape, or form is a notice saying, State of Ohio, just so you know, I'm going to object to certain journal entries that you want to bring in to prove that my client is a repeat violent offender. In no way does that actually ask the state to do anything or the court to do anything. And those are the types of documents that end up tolling speedy trial time, is when the defendant asks for something to be done that requires the state to respond or the court to take some action. This notice didn't ask anybody to take any action whatsoever, and it doesn't fit the definition of a motion in our civil rules or even the definition that's in Black's Law Dictionary. So it did not operate to toll the speedy trial time. So the journal entry filed on April 30th was still beyond the speedy trial time. Even if the state is also correct, let's say that was a motion, it's still beyond the speedy trial time. This entry was filed 15 days late. The state has also claimed that there are some days that are chargeable to Mr. West for his request for discovery, and has said it's either 7 or 10 days. Even tacking 7 or 10 days onto April 15th still makes that entry out of time. So again, Mr. West's speedy trial rights were violated. So at a minimum, because, you know, the essence of due process being essential fairness or fundamental fairness, when we as a society create rules that govern how we do justice, we do have to then make sure that we are careful in crossing the T's and dotting the I's. So unfortunately for the state, the I's were not dotted, the T's were not crossed. And as a result of that, under State v. Mincy, Mr. West's conviction must be overturned and his case discharged. That means under both 2945-73D and also double jeopardy, he cannot be retried for this case. But Mr. West also challenges his convictions as being against, or as not being supported by the sufficiency of the evidence, and also as being against the manifest weight of the evidence, and also that there was a prejudicial show-up identification by the state's key witness in this case. As far as sufficiency is concerned, and manifest weight also dovetails with that, Mr. West's contention is that the evidence presented in this case does not support an aggravated robbery charge, because the evidence was not sufficient to show that at the time a knife was displayed to Mr. Game, who was the victim in this case, that my client was actually fleeing from the commission of a theft offense. The theft offense was the taking of Mr. Game's briefcase from his truck. Sorry, Your Honor. And but the established case law, for instance in State v. Thomas, says that there has to be a confluence of the fleeing and the weapon. Okay, and fleeing.
The weapon has to be brandished during the fleeing, or just in the possession during the fleeing?
For aggravated robbery, it has to be brandished or used. So possessing it during the theft offense or during the fleeing. No, I'm sorry, Your Honor, I'm getting that wrong. I think that
that's why I asked, because I can't remember.
I'm getting it confused now too, but The key for Mr. West is, did he brandish this knife while he was fleeing? And the answer is no, because fleeing requires some haste. It requires, basically, to be colloquial about it, getting out of Dodge to get away from, after the commission of the theft offense. And in this case, there is a period of time that elapsed between the time the briefcase was picked up off of Mr. Gaines' pickup truck front seat and the time when the knife was brandished. And this very closely dovetails with the Thomas case, in which the Ohio Supreme Court said, no, this wasn't, the Thomas case involved actual physical harm done to a police officer who was trying to apprehend a shoplifter at a grocery store. And probably the best way that I can describe the facts of Thomas and why they dovetail with our case is by consulting my device and just describing, the court only gives us a paragraph about what happened. But it seems that Mr. Thomas, the court will indulge me, Mr. Thomas had been observed leaving a grocery store. He had 2 bags of merchandise that he had not paid for. Soon after he leaves the grocery store, he drops the bags. But a police officer, Officer Kraska, sees him and follows him into a laundromat. And this is just like Mr. Gain, who sees this figure walking away from his pickup truck, follows the footprints in the snow, goes back behind a building, follows this person.
But in Thomas, as I recall, the scuffle happened as they were returning from the laundromat to the grocery store. And in our case, the brandishing occurred, it seems to me, as your client was sort of on a continuous route of following, or as the victim was on a continuous route of following your client, arrived around the corner and observed him, going through something. And that's when the knife was brandished. So that's a little different fact pattern, isn't it?
Not terribly, actually. I mean, one of the things that I take from Thomas is that, just as in this case, it didn't matter to the Ohio Supreme Court that you have a police officer who's following. The pursuit itself is not germane to the analysis. If it were, then Thomas would have turned out differently. Mr. Gain pursued the footprints in the snow. He arrives back there, he sees a person who has stopped and who is going through something. Mr. Gain was never sure whether it was actually his briefcase that was being gone through. Mr. Gain exchanged words with the person, who, after exchanging words with him, then brandishes the knife and says, get out of here. In Thomas, you have the police officer who follows him to the laundromat, returns with him from the laundromat to the store, and when they get to the store, that's when Mr. Thomas strikes the officer in the head with his forehead. So that became the gap of time, the break in the chain of between the theft offense and the assault on the police officer, essentially. So that's why I would submit that Thomas is very, very like this case, that the pursuit does not continue the course does not establish a course of fleeing.
I guess to go back to the definition of fleeing, and I think that you have shared that the statute does not define it, but there is this sense of removing oneself from the the place where you would like not to be discovered. And I'm wondering whether or not there has to be running or trotting or moving quickly if you are just trying not to be discovered, which is something that the state raised in its brief that, that if this is the middle of the day, had he taken off running, it would have probably brought more attention to himself. So the fact that he just is continuing to walk away should still be considered fleeing.
Well, I think I have two answers to that. First of all, the dictionary definition requires some haste to be involved. And I would submit that the state's definition of fleeing, which in closing argument, the state in this case actually said included rifling through the briefcase, is overbroad. Because under the state's definition, for instance, if I were to escape from this podium, this would be fleeing, me taking one step to the left. Because, and also I would point out that under the specific facts of this case, because this is always a fact-specific inquiry, that what we have is not actually during the middle of the day. Here in June, it would be during the middle of the day to be at 4 o'clock in the afternoon. In December 11th, it's getting to be dusk. In fact, Mr. Gaines said it was dusk, it was snowing. So, and to Mr. Gaines, seeing people walk by was, he didn't think anything of it. So merely walking away from it, I guess, walking away wouldn't create any attention, but he might not have thought anything of somebody running either. And looking at some of the photos that are in the record of the game establishment, there are very few windows. So somebody running past there would not have necessarily been noticed either.
And counsel, I need to come to reach the end of your 15 minutes of time unless there are questions remaining. Thank you for your presentation this morning.
Thank you very much, and again, I urge you to reverse my client's convictions. Thank you.
Court will take the matter under advisement, issue a written decision which will be mailed to both sides as well as posted on our website and the Ohio Supreme Court.